Thank you
Tell
so
me
much.
what you want me to do. Tell me
Okay,
what you want me to do.
what we'll be doing is that the mentees that are here, they will just present, and then after they are presenting, you have about 5 minutes probably to just comment on what they are what they presented, and direct them in the right path or just comment them.
All right.
Yes. So I don't really have like a long profile for you. I was trying to ask for no.
Don't worry about profile. It's not about me. Let's get them. Let's hear the ladies.
Okay,
Don't
okay,
worry.
okay, ma. Thank you very much.
You're
So
welcome.
we will just start the presentation immediately. Um, I'm I'm hoping that everybody is here. We're supposed to be six, but I think that we're not complete. But for those who are here, we'll just start the presentation and then we'll go forward that way. So we'll be starting with Tolu Lope today. Tolu, are you ready? So you just introduce yourself, Tolu, quickly, and then you can share the screen and start immediately. Tolu, let me know if you're ready. Okay. If you're not ready, then let's go to Michelle.
Juliana,
Yes, I can
can you
hear
hear
you.
me,
Are you ready?
Juliana?
Yes, I can hear you. Are you ready?
I'm sorry. Yeah, it appears my network is crappy, but I can start.
Okay. Okay, so please start. Thank you.
Is it possible I share my screen?
Yes, yes, please, you can.
Okay, thank you. Oh. See, I'm trying to. Sorry. Okay. So can you see my screen?
Yes, we can see your screen.
Yes.
Yes.
All right. Good evening, everyone.
Good evening. Yes, Tolu, we can hear you. You can continue.
Good evening, we were limited. It was just one-pager document, so I couldn't express my thoughts. So I already planned breaking it into different parts so that I will have enough understanding of the topic. So starting with intellectual property rights. So it has been observed that over the years that effort has been made to promote intellectual property in the country, but due to low public awareness and sensitization, poor implementation of existing legislation and inadequate structure and mechanism to address intellectual property in the country. So we have recorded minimal results. So, and this has brought about intellectual property rights and intellectual property protection. And one thing we need to understand is that intellectual property starts from the mind. It's a creation from the mind, and it doesn't protect ideas, it protects expression of ideas.
Tolu, are you there?
Intellectual property works it protects. We're talking about musical works, we're talking about cinematography, film, sound recording, copyright. But bringing us down to Nigerian laws, it has been observed that Nigeria has four types of intellectual property rights, and which are the copyright, we have the trademark, we have patents, and we have industrial designs. And when we are referring to copyright, I'll just briefly touch on each one of them. When we are talking about when we're referring to copyright, copyright protects original work of authorship. Yes, and it also protects a work that is fixed in a tangible medium of expression. Can you hear me?
Yes, we can hear you. But your line is breaking anyway.
All right, sorry about that. So it states, he gave us a list of works that are protected under copyright, under the copyright, and the works are.
Okay. I guess that her network is really poor. So probably, Tolu, maybe you try again later. Michelle,
I'm back.
maybe you try again later because your network is breaking. Can you hear me?
Can you
Yes, I can hear you, but your line is breaking. Okay. Michelle, please, can you just start and then maybe after a while, Tolu can try again.
Okay. Please, can we see the screen? I hope.
Yes, we can see your screen.
Okay. Um, so I basically just wrote a continuation of the relationship between intellectual property and technology that I started on last during the last meeting. Um, this time around, kind of focusing on patents and trade secrets. Not really focusing, but then. Okay. So intellectual property laws have had an important impact on the tech industry's success, like has been said before. IP protection, for example, has given software developers now, for example, or even though software is not doing technology developers in general, the incentive to invest in developing and marketing new programs, new technologies. How? If I develop a software, I develop a technology, the idea that I am intellectual property laws are going to protect my technology will give me the incentive to produce or to manufacture even more technology or to invest my time and finances in even more technology. Without intellectual property protection, second commerce, which is basically somebody that comes in after the first person has done their IP work or their invention work or anything like that, could simply copy the innovation and then appropriate some portion of the economic value of that technology. The same way, just like I said before, so if an inventor comes out, puts in a lot of work, time, finances into a particular technology, and ends up not protecting the work by with patents or with industrial designs or anything, and somebody else, which is referred to as the second comer here, can come in and then appropriate that work. So he can take a particular part of the technology and use it for his own production, and then what that leads to is that the economic value of the original technology or the original invention will be reduced. Tech innovators utilize these IP rights to protect their programs against third-party appropriation. So they utilize trade secrets, copyright, patent law. Patent law, just like I spoke about already, is one of the best protections you can get for a new product that you get. And a patent gives its inventor the right to prevent others from making, using, or selling that patented subject matter. And the key issues in determining whether you can get a patent are whether the product is patentable, and then that invention must be a new or novel invention. There must be nothing like this or nothing like it already in the market. It must not have been patented already or publicized already by anybody else, and then it must have a useful purpose. On the other hand, trade secrets, and trade secrets is one of the main IP rights that is utilized by a lot of technology companies like Google, Microsoft, a lot of these big tech giants. They use trade secrets because they have a lot of employees and they know the value of the work that they are producing. So if you're an employee for Google, for example, or for a tech company or an inventor, anything at any of all those technology companies, you will probably be required to sign a non-disclosure agreement, which they will use to protect their trade secrets, basically, which they use to protect the maybe perhaps the drawing of their invention, how the invention works, which is unique from how other inventions work or how other technologies work. For example, a trade secret right allows the owner of the right to take action against anybody who breaches an agreement. Yes, that's another. So it also helps in taking legal action now. So if peradventure your employees sign a non-disclosure agreement, as long as you can show to the court, or if it's an arbitral tribunal or anything like that, that you had a trade secret right over this particular invention, and perhaps a contract was signed or something like that, you are actually allowed to take action against anybody who breaches that agreement, breaches that confidential relationship, or who steals it, uses it for their own personal gain, for their own personal economic gain, for example, something like that. Yes. Thank you. Maya, you're muted.
Okay, you want me to comment now?
I don't know.
Yes, ma, please.
Okay.
Yes. Sorry, I was
Okay.
muted. You have like about 5 minutes to talk about
5
what she
minutes?
has said. Yes,
Okay,
ma.
just 1 second.
Okay. Okay, so I was saying that we have we have Mrs. Lara around, and we also have Dr. Chijioke. So by the time you're through, ma, Dr. Chijioke can also give her own comment on what Michelle just presented. Thank you.
Okay. Thank you, Michelle. That was very insightful. I mean, you mentioned that you were starting from. Unfortunately, I missed your last meeting, so I missed your presentation. But I liked you addressed patents and trade secrets. And I liked what you said about patents. Yes, it can improve on technology and all of that. It's easier, you know, how do I say this? We all think that everyone thinks that their invention is new. Everyone thinks they can get a patent. Everyone thinks, oh, a patent is what I really need, for my invention or for my intellectual property. But one thing you must know about patents is patents last for 20 years. You have a monopoly. Yes, you can do business with it, you can license it, you can you can do all sorts of things with it. But it's 20 years, and then after that, that's it. In technology, do you really want to patent something that you've developed and hold on to it for 20 years? Think about it. Think about the software. In the last, easily, I'd say 5 years, we've had various iPhones, different, versions. What will be patented will be something really inside there that, for you to be a second comer and take advantage of it, I mean, you really would have had to go and do a lot of reverse engineering. Do you see what I mean? So what you said is perfect. I mean, yes, everyone in my practice, okay, so I've practiced for, gosh, too long that I don't want to share. Nearly 30 years. And in my practice, I always have people come up say, I want to patent my this. I've done this thing, I want to patent it. I'm like, you can't get a patent for it. Is it novel? For it to be novel, it means it's never been seen. However, in some countries, unfortunately in Nigeria, we don't have utility models. In some countries, we have utility models, and it's in our draft law. So utility models are like they call it petty patent, so like a baby patent. So it's not entirely new. You've reverse engineered on what exists. You're maybe second, third, fourth comma. But as somebody said earlier, your expression will be protected because you've put some thought into doing what you did. Um, I mean, I can go on and on about patents. I love patents. But so the things, so you find like with pharmaceuticals, you know, patents are very, because somebody gets that. Imagine whoever it was, if it was Pfizer, whoever it is that gets this vaccine that actually hits the nail on the head, the first person to get it and there are no issues gets the patent. And then you give licenses. So imagine if you are, an inventor. There are people whose job it is they just invent. They don't want to develop, they just invent. They sit in their dark room and they spend all that time. And so when somebody wants to invest in it, they may have to assign that patent away to that person or license it for a year. For trade secrets, I love trade secrets. Really, I always say, what is a trade secret? So you mentioned, something that, is unique to that product or to that business. Yes. So you find that practices, businesses, instruments, designs, patterns, formulae. There's certain drinks. I'm not advertising anybody's drink, but there's certain drinks that we're told that it's a trade secret. That ingredient that nobody knows what it is. But will you the minute you register a trade secret, it stops being a secret. So how do you protect a trade secret? Because the minute you put it out there, that's it. So that's why the law will recognize that. If you patented it, then you only have 20 years protection. If it's a trademark, it's just a name, and so you won't really benefit from it. In other developed countries, trade secrets are protected, and TRIPS actually refers to that, defines what a trade secret is. But I liked what you said. It made me want to go back to school. Well done, very well done.
Thank you.
Thank you very much, Ma. Dr. Chijioke.
Okay, hi everyone. Hi, Mrs.
Uh,
Kayode. Pleased to it's a pleasure to see your face once more. I'm sorry that my video isn't showing at the moment because of where I am. But before we finish, you guys will have the opportunity to see my face.
wow.
Um, thank you very much. Thank you very much, Michelle, for your presentation. I think it was very well put, and just like Mrs. Kayode said, it made me also want to go back to school. The only thing that I am going to add is to say that, of course, there's for each organization, for each business, there's always a dilemma, between should we patent this, should we, go the way of trade secret, because each one comes with its own headache, if you may call it that. So again, for patents, because of the duration, 20 years might sound like a long time, but in an industry that is very much disruptive in terms of the kind of inventions that happen in such sector, 20 years is a short time. It's not long enough for you to get the benefit of all the money and all the resources that you would have put in towards getting a patent. And then again, it depends on the environment. Currently, Nigeria doesn't have an examination system. So when you put in an invention for patent registration, in most countries, especially in the developed countries, they would examine the patent. So they will look at it critically. They will, check the invention to be sure that it works. They will check that the invention doesn't infringe on prior art. So you're not telling us something that is already existing. You're telling us in a new, you're giving it to us in a new language, in a new in a way that will make us not realize that maybe this is actually what you're talking about, So that examination process means that by the time a patent is granted, it's granted to, inventions that qualify for patent registration. Nigeria doesn't have that at the moment. So what we just have is basically a filing system. For trade secrets, it comes with its own issues as well. As much as it can be easier to protect inventions with using trade secrets, when or if you have to consistently work hard at keeping the trade secret. And if, for instance, you are alleging that someone has infringed on has disclosed what should be your trade, what is your trade secret, the court will also want to look into the steps that you took in keeping the trade secret. So if you had gone about the trade secret in such a way that it's no longer reasonable for a court to conclude that you actually kept this thing secret, it's actually a secret, then the court will feel that it was disclosed in the normal course of events. And then, of course, during trade secret infringement trials, there's always the party who is alleging that its invention has been disclosed would always want to have the court hear the matter in closed behind closed doors, not open the trial to the public, so that the person will not, in trying to say this is the secret that was disclosed, you now don't end up after the trial now actually disclosing the secret. So when you go through, if you have the opportunity to go through courts record of court proceedings in trade secrets matters, you will just notice that everybody's talking in coded language. Nobody wants to say this is the secret that was disclosed, So those are the kind of nuances that I think makes IP sector exciting, and those are the kind of things that you would be conscious of when you decide that this is an area of practice or research or whatever that you are interested in doing. So I'm going to stop here and listen to more. Yeah.
Thank you very much.
Just one more comment. Sorry, Juliana. Just one comment
ma'am.
I wanted to make. Just following up from what Ms. Chijioke said. So really, what's the way out? So imagine your client comes to you, I have a trace, I have this thing. What do I do? So we just use contract. So you use a regular law of contract. So you have an NDA, confidentiality agreement, and hope to God that they will abide with it. In like we said, like in Nigeria, there's a lot that we need to do. But I think your generation is probably more, I would say, a lot more honorable than those ahead or those before them. So they probably would. I have hope in your generation that they would adhere to NDAs, and you guys you're very creative, so you find that there's a lot going on, and so tying yourself down, really, you don't want to do that because you're moving. Thank you.
Thank you, Ma.
Thank you very much, Ma. Okay. So let's hear from Clarice. Clarice.
Sorry, good evening, everyone. Can you hear me?
Yes, we can hear you, but your background, it's noisy.
I'm so sorry. It's 7 p.m. here, so I just sat somewhere to attend this class. So I'm so sorry. I hope I'm clear enough.
Yes.
Or do I have to move?
You can share your screen if possible, or If you prefer us to move you to a later time, that's fine.
Okay. Okay, so my topic was intellectual property in sports, and I chose this because these days sports is not only leisure, it's also a way in which creatives and inventors can benefit commercially through intellectual property rights. So in sports, we have different sectors. We have the sports teams and leagues. We have the broadcasting because they're the ones who showcase the matches. We have the companies that produce sports equipment such as hockey sticks, balls, and etc. So I went ahead and looked at the relevant IP involved in the sports industry. And the first one is copyright. Copyright, as we know, is a bundle of exclusive rights that is given to authors of literary and artistic works. Such people include novelists, poets, photographers, architects, people who work in the films, broadcasts, computer programs, etc. And these exclusive rights include the economic rights, where now the creatives get to benefit commercially. This can be the right of distribution, performing the work in public, um, yeah, those ones. And then we have the moral rights, such as the right to attribution and the right to object to distortion of the work. So in sports, works that can be copyrighted include the pamphlets, the programs for the games. We also have the sketches for the merchandise that is being sold during those games, such as the water bottles, the cups, all of them can be copyrighted. We also have the software that, where people go and bet, the betting sites, they can be copyrighted. And the broadcasts, they fall under copyright. The next is patents, and as it has been discussed, patents are granted for inventions, and to get a patent, your work needs to be novel. It means there should be no prior art. It needs to have an inventive step, meaning it should not be obvious to a person that is skilled in that relevant field, and it should be capable of being applied in a certain industry. Things that can be patented include sports equipment, like for example, the breathable shoes. Those ones, they can be patented. Nowadays, we have new technologies that can help athletes to swim faster, to cycle longer. All those things, they are patentable. Another is the industrial designs. Now, industrial designs cover the aesthetic aspect of a product, and studies have shown that people buy products because of how they look, how if they're aesthetically pleasing, people tend to buy them. So this industrial designs can sports comes in because the sports equipment. If I see, let's say those dumbbells that people use in the gym, if I see a cute one, I'm going to buy it because it's aesthetically pleasing to me. So industrial designs are very important. Another thing is trademarks. Trademarks here, they're used to distinguish goods of one enterprise to those of another. And things that can be trademarked include the words, letters, logos, numerals. These days, even sounds and scents, all those, they can be trademarked. Um, we've seen a couple of players, these football players like Jesse Lingard. He trademarked his nickname J Links, and he's using it and benefiting commercially from it. Here in Kenya, we also have a football club called Gor Mahia, and they trademarked their that name, and they're able to sell merchandise using that name and benefit commercially. And another one, the last one, is trade secrets. This one has already been talked about, but I'll just add that trade secrets, but for it to be a trade secret, it needs to have commercial value. It also needs to be known by very few people, and the person who owns the trademark should have undertaken steps to actually protect it. that's all. Thank you.
Okay. Thank you very much, Clarice. Okay. Mrs. Lara.
Yes, sorry. Okay. Thank you, Clarice. Um, I, oh, where's your, I actually had it open. Your screen's gone. Okay, so that was, thank you for that. That was very nicely done. I like IP and sports. I like the topic that you picked. I think that was quite ingenious, actually. I mean, that's very good. And it's something that we really don't pay attention to. Merchandising marks, merchandising rights, you can, I think it's a number 7. I don't play football. I don't watch football. I'm not really a football person, but I think a number 7 in some, I don't know, in Barcelona or something, or when Beckham used to play football, I think he had a particular number, and and all of that, and so if you saw that, you associated it with him. So really, I mean, you've gone through all the rights that ordinarily you would. I liked what you brought out with regard to the sports. I'm actually trying to open up your paper. I have a copy here. Yeah, okay. So I liked what you said about this, the faster way to cycle, to swim, and all of that. Those are areas that, I mean, years ago were not relevant. So I think IP, when people talk about IP, it's difficult to say, oh, I'm only going to have one bundle of one right in a product. In a product, you could have a bundle of rights. You could, I mean, so for instance, imagine, let's say, a spinning bicycle. I don't spin, but I don't know why it's come to my mind. So there's a particular spinning bicycle these days that's, you can ride, especially with the pandemic, you can ride with your friends across the world. Everything is done digitally. So it's got a name, so it's got a trademark that will protect it. There's something novel about this bicycle. It's a new way of, spinning, So they will obviously had hopefully be able to get a patent for that. And then the copyright, the design, the drawing. The minute you write your name, every creative expression, that's what the law protects. So the minute I sign my name, I have copyright in that scribble. So the drawing of that bike, imagine, and then the trade secret. There may be a trade secret. There's, as you said, a dumbbell. It's maybe it's a pink dumbbell, and you think, oh, that's really nice. So whoever it is that from decided to do that, added something to it, so make it pretty, make it aesthetically pleasing. And then trade secret. You could have a trade secret. There could be something that the name keeps coming to my mind, but I won't mention it, about this bike that is special because it's very expensive. And for it to be that expensive, there has to be something special. And you see, these rights, I think we overlook as consumers even. Don't even think as an intellectual property person, lawyer, mentee or whatever. As a consumer, when you move in the market, when you go to the shop, what informs your decision to buy a particular product as opposed to something else? Usually you find that it's probably related to IP. It may be the way it looks. It may be, I mean, the example I give all the time is about water. And I have water. So water is water. Bottled water is bottled water. However, when we go into the shop, everyone looks for their favorite. Why? You may say it tastes different. For all you know, they all come from the same place. But because you identify or you allocate a particular value to the source, that is why you pick a particular product. And so that's why, for sports, I mean, people who play basketball are like, the reason why they pay them millions and millions, and footballers get paid £100,000 a week. Really? What for? For kicking a ball? You think that's all there is? No. There's value in that person, which is why they watch them. The minute they do something untoward, what happens? All the brands begin to drop them because you don't want anything negative associated to your product, or to your name. It may just be a name. sometimes it's just the name, you know. I liked what you said about the nicknames, you know, Messi and Jesse Lingard, you know, Jinx. I mean, that's awesome. So it means that, you know, your name is protectable. Yes, I like your last paragraph. For me, I think just drove it home. You know, you says it's all around us, and the more you get involved with IP professionally or, you know, in school, the more you become aware of IP. So you begin to spot it as you go along. So you go into a supermarket and you see something like that, I wonder if that's real. That doesn't look like what I'm used to. So that's what really IP. IP is really, as much as there's an argument and the jury is out that always, you know, it's just to protect, it's you're using international law to protect private rights, but really we really are protecting the consumer. You know, it's the consumer we're looking out for when, you know, you're talking about intellectual property rights. So thank you very much, Clarice. That was very informative.
Thank you, Ma.
Thank you.
So we'll just go to Dr. Chijioke. So we have like about 5 minutes.
Okay, okay. I'm going to even take less because Mrs. Kayode has said it all. Clarice, well done, well done, well done on your presentation, and
Thank
of
you.
course you chose an interesting way to look at the relationship between IP and the sports sector. I'm only going to just point out that when it comes to the sports sector, unlike a sector like the pharmaceutical industry, for example, where the very products that the sector presents to the public, which is usually medicines, drugs and vaccines and all those kind of things, are things that directly translate to IP. For the sports sector, the sector itself is not, would I say, it's not the sector itself that brings out products that are protected, but the things that happen within the sector are things that bring IP to mind. The things that require IP protection to make it stronger, to make it more commercially viable, or to give us returns in terms of profits and all of those things. And you've pointed out the rights that could apply and the areas in which they could apply. I think also that one of the mistakes that people make would be to just assume that, oh, if I have maybe this logo, this drawing or something like that I use in the sports sector, that it's protected by IP. We always have to bear in mind that each of the IP rights under law has its own criteria. So even though you have names, logos and all those things, they still have to satisfy the eligibility criteria for protection in the various laws dealing with each specific IP right. So if it's something that you want to protect using copyright law, it still has to be original, it still has to be tangible, it still has to be fixed in a medium in which it can be perceived, in a tangible medium and all of those things. But there's no doubt that the sports sector is brimming with IP rights. And for IP lawyers and practitioners are involved in the sector, whenever there's even like the Olympics, FIFA World Cup and all those things, I think business booms, because there's a lot of calls and inquiries and moves from clients trying to protect various aspects of their business in terms going into those kinds of international and even regional, national competitions. So well done, Clarice, and I'll stop here.
Thank you.
Thank you very much, Dr. Chijioke. So another mentor joined, but I think he has gone. So we'll just move to our next speaker. Let's hear from Bernice. Okay, so before you start, Mr. Folarin, you're welcome.
Thank you, Juliana. Good evening.
Good evening, sir. So I'm not sure if you followed Clarice's presentation on sports law and if you want to say anything about it before we move to Bernice.
Okay, I apologize for joining late as I had explained to you earlier.
Yes,
I had a previous engagement. I didn't quite catch Clarice's presentation, so I guess I'll probably watch it later.
Okay, sir.
And take a bench on commenting since I didn't watch it.
Okay, sir. Thank you very much for joining us.
Thank you very much.
Okay, so Bernice.
Hello.
Hello.
Good evening, everyone.
Good evening.
Yeah, my work is titled Intellectual Property and the Fashion Industry. It is basically an introduction because we're limited to a one-pager report and it was a bit bulky. So I decided to split it between this week and next week.
Okay.
So I was
sharing your screen, sorry.
My device cannot share because I do not have the copy of it on my phone. Yeah.
Okay.
Thank you. So I was basically giving an introduction to intellectual property in the fashion industry in Nigeria. The fashion industry has grown and it is now generating more income than we ever thought it would have. However, the intellectual property framework to protect these works have not been reviewed or looked into. So the emergence of digital technology and the internet with social media has increased the rights of creative. However, it has also increased the rate of infringement in Nigeria. Although we have the Copyright Act, the Patent and Design Act, the Trademark Act, but it's not sufficient to, protect a lot of fashion designers from the infringement that goes on today, like counterfeiting and the likes. So my work is basically crying out for a review of the legal framework protecting fashion designers, that we need to look into it and see how we can protect these people and their creative work. Thank you.
Okay.
Sure.
Thank you. Mrs. Lara. Okay, she's.
Yeah.
Okay. Sorry, Ma, you can continue.
Can you hear me? I
Yes,
have to
ma'am.
drop off.
Okay.
I see you have at least you have two other people on there who should be able to do justice to the rest of it. I'll try and join back on in about 5 or 10 minutes. I just have to deal with something now. It's
Okay,
a bit
ma'am.
of an emergency. Bernice, thank you very much for your paper about the fashion. I hear what you're saying, but internationally, you find that a lot of people there's some fashion items that become classics, and they do have some element of protection. So you find that even when your fashion designer client walks into your office, she's hoping that, or he or she is hoping that you are able to assist them. In their drawings, there's ask them to keep records. So in their drawings, they can have copyright. They're artistic, they're different. So even if they're going to make run-of-the-mill shirts and whatever, there has to be, if you want to claim protection, then you have to be really that bit like I think it was Ms. Chijioke that said that you can't just throw something together and decide that I have a right. So you have to be artistic, you'll get protection over that. The name of your product, you could name your dress something. I mean, there's the bags that we know, the bags that have names, they're protected, they have trademark names. It doesn't mean they're not copied, but at least they have a right that can be enforced. I'm really sorry to drop off. I will try to come back on, before you finish. But if I don't,
Okay.
I've had a fantastic time, and thank
Thank
you
you.
so much for inviting me.
Thank
Thank
you
you.
very much, Mara, for everything. Thank you for joining us too.
Welcome.
Thank you. I hope that you'll be able to come back.
I
Thank
hope
you.
so.
Okay. Dr. Chijioke.
Okay, Bernice, that was short. um, I know that there's a lot to talk about in the fashion industry and its relationship with IP. I'm just going to say to you guys that in as much as there's clamor to protect the IP rights of fashion designers, there's also in significant in some respects, or in many respects, there's also a negative side of IP rights in the fashion industry. And that's where my mind went when you were talking about IP and the fashion industry. And the negative aspect is the fact that there are what we call traditional cultural expressions and indigenous knowledge and cultural designs and cultural expressions, and in some laws what is called expressions of folklore. Internationally, especially in developed countries in the global north, there's usually sometimes where they copy traditional cultural expressions belonging to indigenous communities, most of which are found in developing countries, especially in Africa. So you would see a particular big fashion house copying the Maasai tribal clothes from Kenya. You would see some other ones copying something from maybe a religious drawing, or a sacred drawing from Indonesia, from so many places. So increasingly, whilst there's move and voices saying let's have more IP protection for the fashion sector, there's also that aspect where you're worried that they would be the ones to then be claiming that they have intellectual property rights over what is actually the IP, or maybe at least the traditional knowledge or cultural expression of a local tribe. So maybe when you're next week, when you do like the part 2 of your presentation, I would also like to hear you talk more about that, and tell us what you've discovered in that aspect of fashion and IP. So that will be all
Okay.
for me for now.
Thank you very much, Doctor. Okay. Mr. Folarin.
Okay, thank you, Juliana, and to Bernie's very interesting conversation, very interesting topic. I think there's a lot to be said about the intersecting lines between fashion and IP. And thank you very much to Dr. Okorie for also bringing up an interesting aspect to another intersecting area, which has to do with traditional knowledge, traditional cultural expressions, and so on and so forth. I think in terms of, we don't say enough about those areas, and I think that's an interesting perspective. I should quickly state that once again, say well done, Juliana. Thank you very much for putting this together, for having me. Miss Kayode, who left some time ago, actually was my boss. I worked for Miss Kayode almost a lifetime ago, but I worked for her several years ago. Sadly, she's gone offline. So very quickly, I think fashion is a business. Well, the fashion industry is commercial in nature, and so the objective of the industry is to, like all industries, to make money. One critical objective, and so any conversation about IP, I think, should be centered around ways in which people in that industry can ethically, create value, make money, protect their innovation. In Nigeria, of course, when one talks about fashion, the two areas that come to mind immediately are industrial designs and trademarks. So they're like the two, hot button areas, or IPRs, if you may. With regards to industrial designs, I conducted a what you may call a pocket research some years ago, and I discovered that the textile designs that were registered at the designs registry, where a large number of the designs were actually registered by non-Nigerian companies. And you had non-Nigerian companies, so foreign companies registering textile designs, patterns, and so on and so forth. There, in terms of participation or in terms of knowledge and awareness within the fashion industry, there's not very much awareness and about the types of intellectual property rights that protect the interests or innovation within that space. And I think there's a lot more to be said, or there's a lot more to be done around awareness. And I find this to be very true about many things in Nigeria today, in spite of the fact that we live in an ocean of knowledge, ocean of information. People are still drowning in ignorance, and so the same is true about intellectual property rights. And one thing you said, very true, very key, that the fashion industry is multifaceted. You didn't use those words, those are my words. But it's multifaceted, and there are several layers and several roles that are played. So you have, I was talking to, I have a client who's a designer, and she's based in Abuja, and so we got to talking about the about the high rate of, it's like a revolving door. There's a high turnover rate in terms of employment, of tailors in Abuja. And I was asking, so we had the conversation about some of the challenges that this raises. And she said the first thing is intellectual property. Because as a designer, she draws a design, she comes up with a design, has a tailor, give life to that design. And then 3 or 4 weeks later, the tailor says, "Madam, I'm going," or he doesn't even give notice, and the tailor leaves. Now that tailor leaves with the knowledge that he or she has, gained from carrying on work for this designer, goes to another designer and then replicates those designs, and these are issues that are very peculiar to, or kind of peculiar to the fashion industry. So to a very large extent, there are conversations around the types of engagements that you have between designers and tailors, between business owners, and employees, and so on and so forth. So I think it's really a very multifaceted conversation. I like the introduction of elements of culture. I tend to think of a lot of things in terms of culture these days. Somebody said I'm a customary law customary court lawyer these days. I said, no, I'm not a customary court lawyer. But we filed an action in Abuja seeking to uphold certain customs or uphold recognition of some cultural practices in the Southwest. So I think bringing culture into it is also very key. But first and foremost, there's the large. So imagine a pyramid. I think the bulk of the people at the bottom of at the base of the pyramid in the fashion industry do not know anything about IP. Many people are not schooled in the formal sense. So you find many tailors, have probably WAEC or WASC or some kind of limited formal education. So beyond that, there's a huge need for some kind of engagement. But this is an introductory conversation, so I would say, well done. I think, in terms of looking forward to imagining new laws that may be passed. In Kenya, they have the Traditional Knowledge Law, Traditional Knowledge Act, which I think Dr. Okorie was referencing, that deals with protecting cultural expressions. And I watched a video some years ago, and someone was making a distinction between a traditional expression. So the argument was that what is the word traditional? Why do we call a Western style contemporary? And then when we refer to African styles, we call them traditional. That they're not traditional, they're contemporary. So when somebody sings, a folklore, or not a folklore, when someone sings an oriki, for example, the person may be reciting, maybe from the Ifa Chronicles or wherever, the person may be reciting, a piece of traditional knowledge or a piece of cultural expression. But if you were to compose a piece using the meter and the rhyming scheme of the oriki, it's contemporary, it's not traditional, and so I think, in terms of, in those places, the jurisprudence is much more clearly defined, and so we can talk about having such a law here. But before we get to that point, I think the first question is, what have we done with the existing laws that we have in Nigeria? If you look out for industrial design cases, you might not find many of them. They are few and far between, and the same goes for patent cases and even trademark cases. Many trademark matters end at the trademark registry level. Some don't even get there. Talk less of getting to the Federal High Court and then up to the Supreme Court and so on. So it's a starting point. I would really like to hear how this ends. Thank you very much, Bernice. Hope you forgive my rambling, Juliana.
No.
Thank you.
No, you made a lot of sense. So,
Thank you.
Okay, thank you. So let us move to who else? Tony. You actually submitted your assignment, but the second one you submitted was also blank. So I don't know. Or you can, if you have it, you can share your screen and explain, or you can just explain the way Bernice did. Hello, Tony, are you there?
Yes, I can hear you. I'm using my phone for the what's this thing called, for the Zoom meetings, and I don't have the document on my phone, so I think I'll just explain.
Okay.
Yeah. So I was also working on cyberspace in relation to intellectual property. I went further on my research. I my assignment talked about cyberspace, how it's a virtual world created by links between computers, internet-enabled devices, servers, routers, and other components of the internet infrastructure. And like I said in the last meeting, intellectual property rights are needed on the virtual space because the world is increasingly becoming a global village, and it provides a platform for a platform for creatives to gain accessibility for their works online. It also provides for like various types of infringement, like deep hyperlinking, framing, meta tags. Meta tags are used in HTML and XHTML documents to provide structured metadata about a web page. Spamming, digital copyright violations, and other infringements. Intellectual property rights like trademark, copyright, and even patents for like computer software or programs or like novel apps are used for protecting a novel idea for works on the cyberspace, the internet basically. And a major problem that this brings up is enforcement of these rights because of jurisdiction. A crime committed online, like where exactly is the person going to get prosecuted, or the person is under which jurisdiction is the person going to um be liable for the infringement of this copyright violation. And there are various conflicting theories related to intellectual property violations and the internet. Um, However, there are various legal principles that are supposed to guide this creation. For example, the minimum contact test. This is a solution where a non-resident defendant's connection with the forum state, i.e., where the state where the lawsuit is brought, they are sufficient for jurisdiction over that defendant to be proper. The effect test is also used to assess the discriminatory impact of credit policies. Basically, the minimum contact test is basically saying that the country that this person is infringing the creative's right. Let's say the person that's put out the work, that his work is being infringed, is a Nigerian. The person is going to get prosecuted, or the person is going to get compensation under the jurisdiction of Nigeria. And the minimum contact test basically just assesses the discriminatory impact of credit policies. Thank you. I'm done.
Sorry, I was muted. Mr. Folarin, please.
Hey, I think Tony spoke over me most of. I'll need to do some reading and research to come up to where she is. You're talking about the impact of IP. Is still IP and tech? I'm having
Space, the cyberspace, and
yes,
the
tech,
internet.
IP, and cyberspace. Give me 1 second.
Okay. Okay, so while we are waiting for Mr. Folarin, I know that there are several protections that can be. Okay, yes. Mr. Folarin, yes, you can continue.
Okay, so I think one thing that caught my attention was issue of what's it called now, of jurisdiction. So the Lex Fora, and I think I find that very interesting. I find it very interesting that many people think there are no laws that apply in cyberspace, or that there's a problem of conflict of laws. In most cases, you find that there are rules that guide the operations of So essentially, the question is, what brought you to cyberspace? If it's a contract, there are often forum rules that determine, what laws apply. With regards to e-commerce, particularly, you find that in e-commerce situations, if it's a local issue, A buys something from B online or using social media or something. A is located in at point A, B is located in point B. There's a harmonization of the laws that apply. And in most cases, if you look at the rules of court, you find you either go to where the defendant is or where the where the contract was executed or where it was, if it's executed in parts, the last place, and so on and so forth. So there's always an anchor point. And if you're talking about cross-border transactions, you find situations where, depending on the platform that you use, there are sometimes rules that govern, disputes that arise. And that, I think, takes me to a very important issue: rules. Whenever we sign up on platforms in cyberspace, there are rules, there are terms and conditions that we always say yes to, but sometimes never read. I used to do a lot of reading. In fact, these days I don't even install apps once I see certain items in the terms and conditions. So it's very important. I remember some years ago, I was part of a client, or a friend's client, a friend's client, yes, had an issue centered around copyright infringement. We were able to skirt through that issue because the infringing work was taken down, but it was taken from a website, a social media website that had as one of the rules or one of the conditions a requirement that the person posting relinquishes ownership of the work. So we were able to avoid what happened was the copyright owner sent a bill to this person and said, this is how much we are charging you for using our work. And so what happened was we now did a backward search, found out where the image was taken from by the graphic designer who used it, and then did a response to the cease and desist, and then the account for profit letter requesting that, or insisting that, first of all, the infringing work has been taken down. Secondly, that because the work was posted by the owner on a forum that allows for public, that divested the owner of his or her copyright in that work, then we had some kind of right to use. Unfortunately, the work was only used on that forum. So I think it's the same. I think an interesting concept, the concept of memes these days. You find memes that go viral. What a meme is essentially a picture or a video or a GIF that uses an expression. Somebody took that picture, recorded that video, but many people are using it. And imagine a situation where Juliana takes a picture, I use the picture, caption it, it becomes a meme, and then I get tens of thousands of followers from sharing that meme. Is that commercial usage? Let's say I become a stronger influencer, that now helps me blow on Instagram. Is that commercial use of another person's work? So I think the question of the rules, the terms and conditions on the platforms that we subscribe to in cyberspace is very critical. How about situations where somebody bakes cakes and shares pictures, and another person who sells cakes takes person A's pictures and uses them, on his or her own to advertise his or her own services. So I think these are very real issues that
Hello, Mr. Folarin. We can't hear you. Um, I'm not sure. I think it's like a network issue. Probably would hear him soon. But I would just like to point out one or two things. So there was a particular client that I had once. He actually started writing sports stories for some blogs and all that. And by the time he was done with working for them, he decided to write to them officially that he would stop, that he would terminate his contract and all that. But by the time he stopped writing for them, they were still picking up his write ups from his blog to post it in their own blog. And it was an international sports site that people actually read a lot. So, what happened was that he wrote a cease and desist letter to the company, knowing that they had like a branch here in Nigeria. So, he wrote to them and then also attached it to the foreign company also. So that's one. And then if you're also looking at because she also mentioned metadata and this thing. So in the musical space also, um most of these sites where these things are being uploaded and all that, as Mr. Folarin said, they have their terms and conditions, etc. So it's good to look at them and then know what they are asking for and all that. And then if someone is infringing on that, and they also have fingerprints for all these things that are peculiar to that particular work that you're uploading. And so if another person is infringing on it, there are like some um, online methods for most of these sites to actually report that this person is using an infringed work, and then they would send that person a private message to know if that person is actually aware that they're infringing, and if they want to counter that cease and desist letter or that complaint that was being submitted to them, and then that person can then counter it. But if a person doesn't counter it, then they will bring it down. So that was the same thing that my client did. By the time he wrote to Google generally, Google now picked all those people that were infringing on it and then brought their work down. So that's also an option. But for the jurisdiction, there are some bodies that are into arbitration that can help also to handle some of these cases. Like WIPO has an arbitration arm of it. So the only thing is that it will cost you, but that's also an option. Um, what else did I want? I'm not sure if Mr. Folari is still here, but okay, he's just joined. But those are just some of the things that came to my mind. So for the cyberspace, generally, if you're not able to reach those people directly, you might report to the platform that they are hosting their site on. So if they are hosting like on Google or something, you can write directly to Google and then Google can send them a message and they can bring what they are doing down if they are not able to prove that it's for them. Same for YouTube and the rest. Once you write to them, they would send a message and then they can bring it down. So those are just some of the steps that you can take before you now start thinking about courts and how to solve the jurisdiction issues, etc. Mr. Folari, so we stopped hearing you at some point. You're welcome back.
Thank you. Sorry, network is so iffy today.
Yes.
At what point? 'Cause I think I may have been rambling.
No, rambling. No, sir.
Okay. Yeah. So I think so I was saying that the question of the rules that govern cyberspace and is not so much about what laws operate. as much as it is about what are the terms and conditions of the various platforms. Because unless you're in the dark web or on the dark web, where quote unquote anything goes, you are operating somewhere. You were talking about a host, you know. I remember the days of, I think Pirate Bay is still alive, but when torrents started, some torrent servers were hosted in the US initially, and copyright owners would obtain injunctions against the people hosting those servers. The servers will be taken down, and then they'll be set up elsewhere. And ultimately, the server services went offshore from the US, and so it went to places that were not so regulated in the Middle East, in some parts of Asia Minor, and till today, I think you have server farms all scattered across the Middle East, around places like Malaysia, in Asia Minor, and so on and so forth, where US laws don't have a direct impact. So you can't go to a US court to request to file a DMCA complaint, for example. But like you said, if the person is enjoying a service that is provided by Google has a very strong anti-infringement or IP policy machinery. So I think to a large extent, but suffice to say that you must operate within a system, so the confines of cyberspace center around the rules made by the platforms that operate on the Web 2.0 format. So it's Facebook, Instagram, Twitter, YouTube, etc., Nairaland, and so on and so forth. They all have their terms of use, and by clicking OK, you are agreeing to the terms of use. So I think what is more important is to take note of the terms of use and how these terms of use treat IP rights, as opposed to looking at it from a jurisprudential or conflict of laws perspective as to whether it's US law that will apply or it's whichever law. Those are issues that conflict of law, international law, jurisprudence has actually already provides some kind of responses to. But again, the question is, what happens when infringement occurs on Facebook? You share. Is sharing infringement? Is it infringing? And like I said, the question of what constitutes commercial value, in cyberspace today is very different from what the framers of the various copyright acts contemplated when the acts were being drafted. For example, like I said, I can take a meme and that meme goes viral. In fact, I sometimes on weekends I look for people that were captured, people who went viral in memes, people who either were part of or who memes were made of, viral memes were made of, and you find there's always a content creator behind it. Someone is recording a skit somewhere and then it becomes a meme and people use it. And a lot of people in today's world, we're talking about commercial value. Clicks are commercial value. Views are commercial, it's revenue. Views are revenue. It's not until Google pays you £1 that you've made money. A view is revenue. It has some economic value. A likes have values, and so on and so forth. So I'm not arguing for a restrictive approach to IP regulation. I'm only just, for me, I think the rules that operate on cyberspace are more man-made and they belong to the companies, the platforms. I think in the future, the future is, in the future, governments will be run by companies. Facebook, Twitter, Google, and so on and so forth. They are the ones who will run governments. But till we get there, we'll need to ask questions about their terms of service, because those are the laws that operate in cyberspace. The terms of service of these platforms, these Web 2.0 platforms. Yeah, but all in all, great presentation. I would like to see us explore these conversations. I think it's more important. I'm always a fan of using what exists. So how much, how deeply have we dug into the laws that exist? How have we used them to create value? Because at the end of the day, the bottom line is, how are you creating value with this IPR? We don't want to be like the Stradivirus. I hope I got that right. The guy who made several violins and then kept them, went to hide them in his wardrobe or in his attic, and then the world was deprived of the sound of this violin. So I think the question is, how do we, and for a country like Nigeria, how do we use IPRs in such a way that people can, there's a transfer of knowledge, because that's the flip side that nobody ever talks about. The question of how many people go to the patent registry to conduct patent searches for the know-how. I was talking to somebody today. He hosts a platform called, what's that thing called again? The policy hangout, something like that, with the legislature. And he was saying they had a conversation with the DG of TED Fund, who was saying that about 1 point something billion naira is earmarked for innovation. It's an innovation fund for universities every year. But what's going on with that money? Big question. So how are we using are we taking advantage of the disclosure implication of the IPRs? So I think I should stop myself. This one, Max is here, before I overshoot my shots. But I think that's for me. Those are some of the issues that would agitate my mind in a conversation about cyberspace and IP. Thank you very much.
Okay, sir. Thank you very much. Welcome, Mr. Max.
Thank you.
Okay.
Apologies for coming so late.
Okay, I know that you must have been very busy anyway.
He was at African Bar Association.
Oh, okay. Welcome, sir. So everybody has
in Ouagadougou. Sorry.
Everybody has presented except Christina. So Christina will just present, and then Mr. Folarin and Mr. Max will do the commentary on it, as in the explanation on it. Another fine attire today. You're welcome, sir. Christina.
Yes, can you hear me? Good evening.
Yes, we can hear you. Good evening.
Good evening. Let me try to share my screen.
Okay.
I'm not able to, but I'll try to see if I can do it in the course of the presentation. So my topic is on nature of the rights of an intellectual property owner and principal features of intellectual property rights. Can you hear me? Can you hear me?
Yes, we can hear you.
Okay. So basically, under the nature of the rights of an intellectual property owner, we have the moral rights and the economic rights. Under the moral rights, it relates to the connection between an author or an inventor and his creation. And this right protects the personal and reputational value of a work as opposed to its purely monetary value. Then the second right is the economic right. This right relates to a creation's commercial value and grants the author a monopoly to exclusively exploit his creation for a certain period. Under this right, holders can prevent third parties from using, manufacturing, and selling the creation without authorization. Then the next is the principal features of intellectual property rights. Under this, we have the property rights. And under the property right, we have tangible property and intangible property. Under the tangible property, it's basically the rights are bundled with the ownership of the property. And the property rights are transferred once the property is sold. Then under the intangible property, it's also known as choose in action. And most form of intellectual property is by choose in action rights that is enforced only by legal action as opposed to possessory rights. An example is a copyright. The purchaser of a book buys ownership of the book as a good, but not the underlying copyrights in the book's content. The music and the movie industries have used this to protect private property from being pirated. While copyright was conceived as personal property awarded to creators, creators now rarely own the rights in their works because most of these copyrights have been sold off by their inventors, most times because they lack proper representation at the time of entering the contract and agreement. Another principal feature of intellectual property right is that it is territorial in nature. IP rights are territorial in nature. They arise as a result of national legislation. It is only effective in the territory of the state or country that is granting it. For example, an IP right that is granted Nigeria only has effect within the territory of Nigeria. It does not give the power any right outside Nigeria and can only be infringed by conduct which occurs within the territory of Nigeria. But under this feature, I have like two issues that I want to raise here. And I want to use the fashion industry and the pharmaceutical industry to raise my point here. For example, there was a time I was on Instagram and a particular fashion designer was complaining that a fashion piece that she produced for a client, she saw it in the market. Igbo boys were selling it in the market. So she now asked the guys that how did they get it? They say they imported it from China. That was where they got it from. So now in this instance now, I don't know if I'm asking a question. I don't know if she has any redress to it because she produced the clothes here in Nigeria and then she's seen another version of it in Nigeria that was imported from China. Then the second issue I want to raise is this issue of this COVID-19 vaccine that is recently the DG of NAFDAC, she said she warned against people buying COVID-19 vaccine online because it's going to have issues on like she said it's fake. So my question here is, I know probably the vaccine that is being sold online is going to have the name of all those popular vaccines in the US and in the UK. So now if they are selling it here in Nigeria, even if the person that is selling it is being caught, will they have any right on intellectual, like will they have any legal action on intellectual property? Because I know one of the actions that will be taken against the person is that the person is selling vaccine that is going to harm the health of people and the lives of people. So those are the two issues I want to raise on the fact that intellectual property right is territorial in nature. Then the third one is that it is monopolistic in nature as well. This is the right to exclude others from his work. The IP right are always vulnerable to challenge challenges by third parties. And most legislation contains many built-in safeguards to ensure that a balance is struck between the rights of the intellectual property owner and free competition. And some of the safeguards requires the owner to pay renewal fees regularly. These are in the cases of trademarks, patents, and registered designs, while others require a regular use of the intellectual property rights by the owners. So in conclusion, the intellectual property law is a global concept that plays an important role in the economic growth of any nation, especially in this age of technological development. It is meant to protect the right of inventors, writers, and also those of artists and the public at large. Thank you.
Thank you very much, Christina. Okay, so let's start with Mr. Marx and then we'll move to Mr. Folarin.
Okay, thank you so much, Juliana.
Thank you. Your network is not really so clear, so we can't hear you. No, we can't hear you. Maybe you'd log in and log out, or I'm not sure, or you can use another device.
Oh, apologies.
Okay, we can hear you now.
Okay, thank you. Apologies, my internet is
Thank you, sir.
dodgy. Is it okay?
Yes, sir.
So can I?
It's actually breaking. Okay, so maybe Mr. Folarin can start, and then while we wait for you to fix it.
I was actually going to say that maybe Max should have a bite at that at conversation, but
apologies,
okay.
Okay. I don't know why the network is not so good today.
But I can't seem to hear anyone.
We can hear you actually, but it's breaking. Mr. Folarin, so maybe you can just help us with it while we're waiting for Mr. Max.
Okay. I think one point that was emphasized greatly was the what's it called, the municipality of. Okay, I think the territorial nature of intellectual property rights.
Okay.
The territorial nature of intellectual property rights. I think there's IP rights are territorial. Okay, Max has given me permission.
Okay.
So yes, they're territorial, but it's not enough for us to just say it's territorial and so therefore, there's a reason why, especially if you look at copyright law, you find several treaties that many companies, I said companies, many countries, become signatories to. And there are so many bilateral agreements and trilateral agreements and all sorts. The purpose is to reach beyond the scope of your borders, your physical borders. And that's the reason why a man called Big Boss Jiggerman, who was one of the most notorious pirates of the late 90s, was operated in I think Asia Minor, from Malaysia and some of those other states, and was importing CDs into Nigeria. But somehow there were successful attempts to stop those activities, the importation of infringing musical works, and so on and so forth. And these attempts were not based on orders obtained from Nigerian courts, but were based on bilateral arrangements between agencies like the Copyright Commission and, foreign partners, quote unquote. So I think to a very large extent, you have a lot of cooperation between countries, and that it doesn't trump, but it waters down the effect of geographical borders. That's not to say that the laws don't have any effect, because as she rightly said, what is infringement? One man's beans is another man's poison. What is infringement somewhere may not be infringement elsewhere. But that is true when you're talking, for me, I don't think there's an issue with cyberspace. I was going to say when talking about every other place except cyberspace, I don't think there's an issue I don't think there's a vagueness as to the application of the laws. If you read the fine print most times, there is a law that applies. At the moment, I understand one of the downs, I think in terms of regulation, you find regulatory agencies that deal with vendors who have online platforms. They don't insist on, there are some clauses that they insist must be in the terms and conditions, but the way cyber virtual contracts operate, often that they operate in such a way that the owner of the platform or the vendor actually gets to choose what the what the rules of engagement are. So, for example, you just get to click OK and yes in many instances, especially when one is working on a scaled platform. So if you're working or if you're interacting with a platform that caters to millions or thousands even, we don't get to customize our experience or customize the application of the rules. So I think that does water down the geographical borders, because most platforms are different from owners in many ways. Platforms in the US, many of these platforms started as US companies, they're now international companies, but platforms in the US enjoy protection under what is called the Communications Decency Act. Section 3 something of the Communications Decency Act insulates platforms from liability, in the event that somebody posts infringing content, and all that, or from liability from libel, and the reasoning is that the platforms are not editors, unlike newspapers who will be liable if anybody, if they published libelous content, they would also be liable, along with whoever published the libelous content, and so on. So the objective of a platform when setting its rules are different from the objective of an IP owner. So an artist, for example, I was going to say a music label or a record label that owns the copyright in songs, does not want to share that copyright with anybody, does not want to usually wants to retain as much control as possible. The platform's concerns are not so much as to how to help Mariah Carey for, that I just pulled that out of the hat, maximize her, revenue streams from her work. The objective is how to strike a balance. So they're like an independent third party. So the concerns in the T's and C's will be different from the concerns that a Tidal, for example, will put on their own T's and C's. And Tidal acts as an agent for owners and for users. So I think there's a lot to be said about it. Of course, when you delve into other IP rights, patents, trademarks, yes, the territorial implications become the more visible, especially with regards to registration. But when it comes to recognition, I think there's a global effort that, of course, you look at the Patent Cooperation Treaty, you look at the Madrid Agreement. So with regards to recognition, there's a global effort to build a coalition that makes it easier to enforce one right in a foreign, or at least to protect it, maybe not enforce, but to protect in other countries. I think I would like to hear a conversation about how the AFCFTA, addresses copyrights, trademarks, patents, and general intellectual property issues. Because, from a trade perspective, there's a lot going on in East Africa and in parts of Southern Africa that are well, from a trade perspective, this might not be politically correct to say this, but that appear to be neo-colonialistic in nature. So you have instances where some countries are indebted to some other countries, to China, for example, and the Chinese have a very strong hold in this country. So what is the impact that the AFCTA or the open borders or the open trade arrangement, will have on a country like Nigeria, which everybody says is the biggest market? I don't see that as a good thing. I see it as a negative, because if everybody sees you as a market, something to be plucked, pumped, feathered, and chopped, then I don't think we're doing ourselves any good if we cannot supply the goods that, if our local producers and manufacturers cannot benefit from the numbers, then it's quite sad that would have to sell those numbers to foreigners. But so there are concerns to my mind, but I'd like to see, it would be good to have more conversations around how the AFCFTA, can how IPRs and enforcement and all that play out in the new regime that we're in. So I'm sure that Max's internet is back up.
Okay, sir.
Thank you very much, Juliana, and well done. Brilliant presentation.
Thank you, sir. Mr. Max. I hope your internet is better now.
Okay. Yeah. Hello. Can you hear me now?
Yes, sir, we can hear you. It has gone silent again. Let me know if it's just me or if everyone here cannot hear Mr.
Okay.
Max.
Apologies. I had to swap.
Okay.
Yeah.
Okay,
sorry.
sir.
I'm using internet connection on my phone, so every time a call comes in, it interrupts the connection.
Okay. Okay, sir.
Okay. Yeah. So thanks once more, everyone. Thanks, Juliana, as always, for having me over, particularly when I have to speak next to my Egbon. So for those who are Nigerians like Clarice, Egbon simply means big brother, but you hear the word, it sounds very heavy, Egbon. So that's the bigness of how big a brother he used to be. So that just gives you context of what I'm talking about. Like I said last week, and I'll repeat anytime, any day, anywhere. Mr. Aluko is one of the people who put me through the paces when I started off completely ignorant in the world of intellectual property. When I was still saying things as ignorant as I want to copyright my patents. So you can imagine where he found me, really below there. And he has taken me somewhere far now. So my gratitude to him and the privilege to speak alongside him this evening. And thanks everyone. I mean, unfortunately, I missed a lot of the presentations, but thanks so much, Christina. You did a great job. I love the fact you put so many disparate topics, very high level topics actually. And you took your time to really, very briefly, but at the same time, very in depth to an extent, break down those topics. I mean, putting a lot of those topics together is really not easy, but I think I enjoyed your presentation, and I believe you did a great job. So I'll just comment on a few parts of it. Yeah, there's one part of it you mentioned, which I think people overlook a lot, which is the severability between intellectual property in a material and the physical medium in which that intellectual property is contained. So typically, this plays out most in copyright. So for instance, there's a case where someone wrote a letter, and the letter was written to a lady. So yeah, the lady owns the letter, but something I think came up, and there was I think it was the lady, I think the guy, the person who wrote the letter passed on. So there was a tussle over copyright, in respect of that letter. So while the letter belonged to the lady, the copyright in that letter belonged to the author, who was, of course, the Romeo that wrote that love letter. So it became an issue, but the court decided that, look, the letter could belong to you, but the copyright in it belongs to the author who penned down that. There's also a case of an artwork. So you could be the owner of an artwork, but that doesn't make you the owner of the copyright in the artwork. So how does this play out? You own an artwork, and then you let somebody take a picture of the artwork and create maybe a calendar, for instance. That would be a apologies.
Sorry, I guess a call came in again. Hello? Sorry, it's like another call came in. Okay, so while we're waiting for Mr. Marx, I'll just point out the fact that, no, we can't hear you. Okay, so I'll just point out that, yes, some of these protections are actually territorial, but that's the reason why we have some of the conventions that we have to just try to unify the laws that we have. And so for copyright,
apologies, I'm back on again.
Okay.
Can you?
Okay, yes. Yes, sir. Yes, you can continue. Okay. Probably he would come back before we round up. So for like copyrights, we have the Berne Convention, and so the Berne Convention has like 100 and I think 70 something countries that are signatories to it. That means that anyone who signs up for it, or for any country that signs up to it, they are bound by the provisions of the Berne Convention. So to that fact, to that particular law, it's not territorial anymore. So those countries that are signatories to the Berne Convention will actually respect whatever you have, and so there's a reciprocal respect in different countries. And for those that are territorial in nature, like for the trademark, patent, etc. So we have like the Madrid protocol, we have the Madrid, I think, system, we have the PCT and all the one for patent, we have the Lisbon, and then we have, I think Lisbon is for JIIPCC. For all those ones too, it depends on the countries that are signatories to it. But even if you are a signatory to it, the owner of that particular work has to register that work in the countries that they want it to be applicable to. So you have the option of picking those countries that you want it to be applicable to. Once you're able to pick those countries, then it's protected in those countries. But if it's infringed in a country that you did not pick, then you do not have a right there. But I don't think anybody has a right to make your work in a country where it's not registered and then ship it down to a country that is registered. So if you register your patent and you choose probably Nigeria, US, UK, etc., and then someone is infringing on that particular work in a country where it's not registered, they're not supposed to be able to bring it into Nigeria when you have a trademark in Nigeria. They will not be able to do that because you own that protection in that place. So for import export, you should be able to guide who exploits that particular work because of the monopoly that is involved in the exclusivity of that particular work. So Mr. Marx is around. I don't know if he wants to try again.
Yeah, okay. Can you hear me now, Juliana?
Yes, sir.
So, Juliana, can you hear me?
Yes, we can hear you, sir.
Okay, thanks. Apologies. I mean, my internet is having Friday attitude. Okay, so okay, thanks. Yeah, so just to wrap up my thoughts on the first on the first issue out, which is on the issue of the distinction. Is it bad?
No, we still cannot hear you for now. We still cannot hear you for now, Mr. Max. Another thing that you touched on, aside from the territoriality of IP protections, was also
Is it by any chance better now?
yes, we can hear you.
Wow.
But you're muted now. So maybe you unmute and then try. Let's hear. Okay. Well, I don't know how we're going to do it for now. But I know that he was trying to make a distinction between the owner and the author of a particular work. I know that the owner of a work can be different from the author of a particular work. And then Christina also spoke about the moral rights and then the economic rights that are in a particular work. So there are some instances where people, when people do a particular work, that they try to assign all those rights. Maybe for an employer-employer situation or for an independent contractor. So they try to make all those distinctions, and some just try to find a way to um, assign all those rights. But it's good to know the distinction between the author and the owner. So it's possible that the author can be, maybe for me now, if I write a book, I might be the author. If I make a painting, I can be the author. But by the time someone else acquires like the economic right and all that, and you transfer the ownership to the person, to another person, then that person becomes the owner of that particular work. So even if you're looking at copyright, there are some times that you see companies will bring a particular song to you and they'll tell you that they want you to register that song and make that company both the author and the owner. And then I try to explain that it's not possible for a company to be the author of a particular work. They can be the owner, but not the author. So the author will still be the original person that wrote the song, but the owner can now be the company. And so it also applies to um, different types of works that falls under the intellectual property. I think that we'll be rounding up now, because we've actually stayed for a while. But I'll just give like 30 seconds to see if Mr. Marx would be able to say something. But if he's not able to, then we would round up for this week.
Okay, can you hear me now?
Yes, sir. Wow. So it has gone silent again. I don't really know what's going on with the network, but
Is it any better now?
yes, I can hear you with your initial statement, but after that, I can't hear you anymore. Okay.
Okay, is it any better now? Maybe I'll just try to still
Yes,
speak.
I can hear
if it
you. I
works.
can hear you, sir. Yes, sir.
Okay.
Or since we are having this issue, probably if you can send a voice note explaining this, and then I can forward the voice note to the mentees, and
Apologies
then
a
we hope.
million times to everyone for this terrible idea.
Okay, so it's coming in and it's going, like it's fluctuating. It's actually fluctuating. But I was saying that if it's possible to get like a voice note for this final explanation, okay. So he'll be sending a voice note and then I'll be forwarding it to the WhatsApp group. Thank you very much for attending, everyone. I would like to say thank you to all the mentors that attended today. We had Dr. Chijioke, but she had another meeting, so she had to leave. We had Mrs. Lara Kayode. She also attended. I think her law firm is O Kayode and Co. And then Mr. Folarin also graced us with his presence, and Mr. Max. Thank you very much. And I hope that by next week our internet will be better. And for the mentees that we have here, please let's try to be punctual. Let's submit our assignments on Wednesdays. Let's attend early, and hopefully we'll be able to manage our time better so that we can even close earlier. Thank you very much, everyone, and have a lovely weekend. Bye.